like to call Dr. Coopers as our last witness.
Okay. Well, okay.
For today.
Is that Dr. Terry Allen Coopers?
I am.
Terrific. I wonder. Yes.
Just the only thing we wanted to bring up regarding Dr. Coopers is first thing this morning when his name was mentioned, said we've never heard of this expert, we didn't know, do you have anything? And counsel said, well, I didn't know until this morning, except I've been told that that was one of the witnesses that they had written down on their list for the hearing last week. And so since the state was not told about them when it was first known, and we would have tried to speak to this doctor at a minimum, if not to depose this doctor, I just want to make it clear that this is someone we had no information about until this morning, and counsel said that they didn't know until this morning, and yet it was on a handwritten note by co-counsel from last week in the court file.
We will not be prepared to cross-examine this doctor at this time, Judge.
May I respond?
Sure.
Your Honor, as I stated before, it was my intention to have Derek evaluated on the 11th or 12th. I'm sure Ms. Morales remembers that. And it was by Dr. Arias. Unfortunately, I couldn't get that done. Therefore, I had to, no offense, Dr. Coopers, but I had to rely on Dr. Coopers, whom has not evaluated Derek.
Well, that was my next question.
He has not.
Has he actually seen this young man?
He has not seen him, however, based on his
What about a review of records?
He has done that.
What records has he reviewed?
He has reviewed the records from the CHS team from the 26th through, I don't want to miss, I'm sure he could tell us, I think through the 29th of November. He has also.
How many records are there?
I'm sorry? How many pages?
Yes.
It was 287 pages. That's what he's reviewed.
From CHS?
Yes, sir.
Are you planning on putting them into evidence?
No. He has also reviewed the activity logs. He has also reviewed the police interview. He has also reviewed I believe that's it, but he could tell us what he's reviewed. And the line.
So when was he provided these documents?
Yesterday when I received them. I received the CHS documents yesterday, Your Honor. And as soon as I received them, I forwarded it to Dr. Cooper. We have a 3-hour difference,
You
thank
did
God.
that in the intent that you were going to call as a witness?
I did, yes. I was debating whether to do that or not, or whether I could just rely on Dr. Bedica's testimony. But based on his expertise, especially in the field of solitary confinement, in the field of isolation.
Sure. But don't you think that Rule 3.220 requires you to make disclosure of somebody that you intend to utilize as a witness at a hearing?
Your Honor, I think that for these purposes, at our particular juncture, the fact that I always intended to call Dr. Bedica and Dr. Cooper's was only maybe a backup, not even, because Dr. Arias was really supposed to be the person that evaluated Derek, so Dr. Cooper's was.
Do you think that if you intend to introduce opinions from this doctor, that the state should have an opportunity to review the documents that the doctor relied upon and the input that he relied upon in reaching any opinions that he might have?
He has not. If he had reviewed something that the state had not, then I would say yes, Your Honor. But I don't see the prejudice given the fact that the records that he reviewed, the state has had them since the first, presumably. So in fact, they have more records than I do. Because Ms. Morales keeps referencing almost 700 pages. I have 287
But they don't know what he's relying upon in reaching his opinions. And we're not talking about somebody looking at a photograph or something that's immediate. He's an expert witness. You're presenting him because ostensibly he would have the educational background and experience to provide help to the court on a subject matter that's not within the normal realm of knowledge. And he relied on documents or materials to reach his opinions. Do you think, in fairness, the state should at least know what he's reviewed and how he reached his opinions before they're presented, as opposed to just blindly cross-examining it?
I think that if the state wants we would not be opposed if the state wants the opportunity to voir dire Dr. Coopers. I don't mind that at all. As I said, I personally.
Wow, you both crossed your arms in identical manner at the same time.
Not intentional, Your
All
Honor.
right, I'm sure.
Your Honor, he hasn't prepared a report. He has not prepared a report. Again, I don't see the prejudice given the fact that the state was always aware that the defense was going to call an expert.
I got a better idea. Why don't y'all go in a breakout room for half an hour and hammer it out, and then you'll tell me whether you need more time.
Judge,
Okay?
I understand that. I just want to make it clear that we completely agree that Rule 3.220 does say that not just things you intend on introducing at a trial, but things you intend
At
on
a hearing as
introducing
well.
at
Yeah,
a
it's
hearing.
different for a defendant than it is for
Correct.
the state, but it's clear from the rule that if you intend to call someone as a witness or utilize specific documents, you're required to give notice of that, even pre-trial, even post-trial. But this rule specifically talks about witnesses at hearing or trial must be revealed. So they come in here in this afternoon and find out for the first time that you plan on calling an expert who's relying on documents and materials that they don't even know what he's relying on yet. And he's going to render an opinion. That's just unfair to ask somebody to cross-examine an expert of this caliber and nature. It's just unfair.
And additionally, Judge, the additional thing is, while counsel said she gave records yesterday, that doesn't answer the question as to why, if that witness was listed on a list of witnesses to be called at the last time we were at hearing, which I think was the 5th, so that's 9 days ago, why?
That part I'm not going to.
Yeah.
Your Honor, it's not even understanding the records he's relying on, because we do have those records, but the purpose of at least being able to depose the person once we know who they are is to refine the issues and to effectively cross-examine. There's no way you can effectively cross-examine an expert at this point, even if we're aware of the records. It's not really unfair. It's just, it will not be effective.
Your Honor, and if they want more time, that's absolutely fine. I just don't see the difference between last night, and again, thank God, him and I, we have a 3-hour difference. Otherwise, it would not have even worked out. I couldn't call him. So based on that 3-hour difference, it was 9 p.m. for me, 6 p.m. for him, and we were able to make it work. I don't see the prejudice between 9 p.m. last night and this morning. I mean, I would parallel it, Your Honor, to when I kept saying these logs are not Derek's, these logs are not Derek's. What happens on the 7th? We come in, Ms. Morales tells me that morning, oh, I heard the logs, they're not Derek. I prepared all night for that. I mean, I don't understand. I'm being handed things the morning of. I'm being handed items, literally, stacks of items the day of. Your Honor signs a motion to compel where records have to be turned over by the 5th. When do we get records? On the 6th. And why? Because we went in chambers and Your Honor put his foot down. I don't see the prejudice in Dr. Cooper's. I definitely don't see it based on the timing of it being last night to this morning. In all fairness, I mean, it's afternoon now, but they knew about it in the morning.
Clear? No, Judge, we didn't.
Wait.
And if they need more time, Your Honor, that's fine.
So here's where we are. I'm pushing this case quickly because you want to get